Hello everyone and welcome to this latest ACT, the App Association member resource video. Today we're going to talk about employment law. The reason we're talking about employment law is because most of our members are micro or small businesses, which means that they are either in the process of hiring their first proper employees, or they might have a handful of employees and they're slowly growing to have, 10, 15 or 20. And that means that they need to understand how to legally and fairly employ their staff, and they need to understand the fundamentals of employment law to make sure they can do that without any problems. We're joined today by some expert speakers who are going to talk us through what companies need to know. But first of all, I'd like to point you to the other videos in this series, which include funding and R&D tax credits and intellectual property for small businesses. You can access those on the ACT website, or they'll be linked in the comments below this video. So I'd like to hand over now to Alice and Tim from IEM Consulting. They're both employment lawyers, they're both experts in their field, and I've been lucky enough to work with both of them in the past and have seen the high quality advice that they give out to companies. So without any further ado, I will hand over to you, Alice, if you could share your screen.
Thank you, Stephen, and we're delighted to be presenting this today. Very important subject, employment law. There are quite a few pitfalls to be aware of as we go through, but we will highlight these to you. But we're going to start with the basics and make it fairly straightforward. And obviously at the end, we will provide contact details for you to follow up with any questions you may have. So without further ado, we're going to be talking about the everyday employment essentials, the things that you really need to know. We're not obviously going to cover every aspect of employment law today, but those that really are truly important. So part one, we're going to cover the basic principles. What is employment? So who is an employee? Well, the actual statutory definition is anyone who works under a contract or service or apprenticeship, and that's the statutory definition. But we'll talk about contracts later on. Contrast that definition with workers, which is commonly referred to, and it's quite important not to mix up employee with worker, because workers have less employment protection than an employee. A worker is someone who works for another, except where they are in business on their own account. So there's a little informal definition there. And then finally, self-employed, who are independent contractors. And we're going to talk also how to differentiate between an employee and someone who is self-employed later on, because there are differences and there are different approaches you can take to find out who's who. So distinguishing employees from the self-employed. So having an employment contract, so written contract, is actually not the deciding factor to identify whether someone's employed or not. Just because they have this contract to say, well, I'm employed, doesn't actually technically mean they are. So if you have a contract that defines someone as self-employed, it doesn't actually stop them from being an employee. It's the other way around. So you may have someone who is self-employed, not on PAYE, and they have a contract to say, we're providing service as an employed person. Depending on how they are treated and depending on what they do, as we will go on now, may make them actually an employee. So there isn't a single test, not to make it confusing for an employee, but there are 5 approaches that employers can take to identify whether someone's an employee or not. So the first one is a control test, very straightforward. Can the employer tell the worker what to do, how to do it, when to do it, and where to do it? Such as, please come to the office every day from 9 to 5. You have to do this, this, and this, set targets. Clearly, that employer would have control over that employee. Secondly, the integration test. Is the person seen as part of the organisation? Do they have a uniform? Are they coming to the workplace premises? Do they have equipment supplied to them by the employer? Do they get given a work phone, a work laptop? Are they in the same group of workers in a particular office? How integrated are they? Do they turn up to work every day with everyone else? It would be a bit odd if someone was self-employed but had all those things under their belt. Thirdly, the economic reality test. So this test sort of takes into account all the circumstances, so everything to do with how they work. So Does the employer have the power to dismiss them? Can they be fired? How are they paid? Are they on the PAYE system, or are they paid on an hourly rate or a daily rate? And does this person pay their own income tax, national insurance? Do they have to pay that themselves, or are they on the system to do that? Fourth, the mutuality of obligation. Is there an obligation for the employer to offer the work, and then an obligation for the individual to accept the work? That would mean that, if you were an employee, the employer has to offer you work to do, and you as an employee has to do it. And we will talk about duties of the employer and the employee later on. And then finally, the last approach you can take is personal service. Is the worker required to perform the service personally, or could they substitute someone in their place? So if you were self-employed, you had your own personal service company, limited company, the company would be doing the service effectively because it's separate from the person. And you could sub in, another contractor perhaps, or someone else other than you, because the contract for services between a self-employed person and that company would probably name the company as the service provider rather than the individual. Whereas if you were an employee, obviously you're the only person that can perform the services for your employer. You can't sub someone in. If I'm employed, I go to work every day, I can't ask my friend down the road to do it for me on the day I'm off. Then they're not performing the service personally. It's you as the employee. So those 5 approaches roughly would enable any employer to determine whether their workers are employees or self-employed. And there's a lot to go through, but generally speaking, this does help most people. So I'm going to hand over to Tim now to carry on through the next couple of slides.
Thanks, Alice. So that was what's an employee, what's a worker, who is self-employed. And it's not always clear. I suppose the message that we're giving you from the first section is just try and have some certainty, because it may be you're already engaging with people. And it may be that you think they're self-employed, but actually, if you think back at what Alice just said and just told us, it may be that actually they're already employees of yours. One of the key things is, do they have a company email address? Are they looked at externally as part of the company? And factors like that go into the round. So it may well be you've already got an employee when you didn't know it, and you only find out later down the track. And that's a situation that we want to help you avoid. So if we now look at the basic entitlements of all employees, so we're concentrating here on employees as opposed to workers or the self-employed. Broadly, all the rights we're going to go through here cannot be contracted out of or denied. Basic statutory rights. So the government has passed laws at some particular time in the past, and these are rights that then lock on to all employees. Some apply on the first day of employment. We'll go through in a minute. Some of these rights actually apply to people even before they start employment with you. Other rights have what we call a waiting period. So broadly, someone has to work for you for a length of time before they get the right that we're going to describe. And as we go through, if there's a waiting period, we'll tell you. Otherwise, it's a day one right. They get the right on the first day of employment. Discrimination is one that we're going to highlight. The discrimination laws in the UK are quite strict. And those discrimination laws apply as part of the recruitment process. So even if you're interviewing someone for a job, then the discrimination laws already apply to that situation, and it applies to other situations as well. It's a very wide-ranging piece of law in the UK, so it could apply, for example, to the self-employed as well. In addition to those statutory rights, those main legal rights, employers can agree additional rights in the contract of employment. And that's very common. And it's very, very common for the contracts of employment to enhance the rights that we're going to describe. So if we just move on to the next slide. So here are some main statutory employment rights. There are others, there are many of these. And what we've done for you today is include the most obvious, the most basic ones, the ones that you're going to need to know about most commonly. Number one, the right to the minimum wage. The minimum wage or the living wage, those amounts are set by government. Generally, they're uprated every April. It's just been announced that next April, the living wage is going to go up again. These minimum wages, they generally are age specific. So they go up 16 17, 18, 21, 23, for example. And as I say, they will go up every year. Don't confuse the minimum wage with something called the national living wage. The national living wage is a voluntary scheme. We're talking about the statutory minimum that you have to pay here. A statement of main terms of employment. Now, this essentially is a contract of employment. It could be in a formal contract, or it could be in a letter that you send, and you have to provide certain information to all employees. It's very basic information. It will say who the employee is, who the employer is. It will set up their hours of work, their days of work, and their main statutory rights. And that is a requirement of all forms of employment. The right not to amounts deducted from wages, except where agreed or under statute. So broadly, once you start paying someone and they're an employee of yours, the law says you can deduct certain things: tax, national insurance and pensions. Student loans would be another. Other than those amounts, the law says you can deduct. Unless you've got agreement from the employee, you can't deduct anything else. So it may be that you've got something in the contract of employment that you will deduct off, I don't know, car allowance or something for car insurance or something of that nature, or something for a laptop. You can't make any deductions from wages except for those limited ones I've indicated, or where there's express agreement. Now, the next one, the main one, limits on working time and rights to paid leave, in other words, holiday. So we've had rules on the amount that people can work, the amount of working time for some years now, and they've been enhanced over time. And there are limits on how many hours someone can work every day. There are limits on the amount of rest time they get between working days. There are limits on weekly rest. So everyone's going to have 24 hours uninterrupted rest in any 7 days. Everyone's going to have 11 hours rest between working days. And there are limits on the total amount of working time averaged over a 14-week period. So worth being aware of those working time limits, and everyone gets a right to paid leave in the UK. So that can be varied by a contract, but broadly everyone gets around about 25 working days leave per year. But it can be varied by contract, and it can vary depending on the hours that someone works, so you can prorata it. Protection from discrimination under the Equality Act 2010. We're going to say a little bit more about that later on, but worth bearing in mind that although those rights exist, the bits that I've covered so far, if you breach that, then an employee could take you to a tribunal. They're fortunately rare, but it's possible. It's worth bearing in mind that those Equality Act rights, those are quite strictly enforced, and the damages, the compensation tend to be quite high. So that's why employees tend to be very careful around discrimination and equality. The right not to be unfairly dismissed, that's subject to a 2-year qualifying period. So unless someone's worked for you for 2 years, they don't have that particular right. Compensation if they are made redundant, again, a 2-year qualifying period. And the right to a period of notice. So if you wish to let someone go, dismiss them, then broadly you have to give them a period notice, the employer period notice, before they will finally leave your employment. So lots of other employment rights, but those are a snapshot of the main ones. If we move on to the next slide. So implied duties, I'll cover this slide off and then hand back to Alice. So as well as those statutory rights that we've gone through, the law over time has implied into employment contracts other duties as well. These are all still legally enforceable. So from the employer side, a duty of trust and confidence, and that broadly means there's an obligation to treat employees fairly, but also in a way that doesn't undermine that. So if you treated an employee unfairly and that trust and confidence broke down, potentially they could leave you and they could say, well, you breached the terms of my contract. It might seem obvious, but it's not a statutory right, but the law has implied a right, a duty to pay wages. A duty to take reasonable care for health and safety. A duty to provide work, question mark. Why is there a question mark there? Because the duty to actually provide work, that isn't always an absolute duty. There will be a duty to provide work if, for example, you've got an employee and their pay is partly dependent on their performance. So it may be commission-based or bonus-based, and then you do have to provide work. If it's a straightforward hourly rate or salary, then broadly you don't have an obligation to provide work. It might seem strange. A duty to provide a reference, question mark. No absolute duty to provide a reference to anyone that leaves you. If you do provide a reference, then you've got to exercise reasonable care and reasonable skill and provide a fair reference. The employee side, a duty of obedience, and that means a duty of loyalty to that employer. And it means that broadly the employee shouldn't be working for a competitor at the same time. A duty to provide personal service, as Alice has explained. You can't generally substitute in another worker for yourself. Duty of trust and confidence. Now this flows two ways between employer and employee, and clearly the situations where this can break down, and that can lead to an end of employment. Duty of good faith, loyalty. And within this bucket, we've got avoiding working for competitors, keeping the secrets, the trade secrets of your employee between yourself and not telling others about it, not passing on customers to other. And also if the employee out of their employment makes a profit in some way, so it may be that they separately do some work for a customer of their employer and get paid for it, well, that money belongs to the employer, not the employee. So a snapshot of these other duties that also apply where you've got an employment relationship. If we move to the next slide, and I will hand back to Alice to cover some common issues encountered with employment rights.
Thank you, Tim. As we said at the beginning, there are a few issues that you may encounter as an employer or recruiting new staff. These are the main issues that come up time and time again. So you're not alone in worrying about these topics that we're going to cover off right now, because people struggle with these issues, throughout their careers and employing people and within their own companies, because they always throw up little niggles here and there. So one of the big ones is sick pay, statutory versus contractual. So there is a minimum statutory sick pay. You've heard of it before. It's called SSP. It's set by the government, and that is a statutory amount of sick pay that the employer can offer to their employees. It is capped, it is limited, so it doesn't run forever. So your employees can't be off sick for an indefinite amount of time, but the sick pay is there as a base level. Employers, if they wish, and they don't have to, can offer contractual sick pay, and this must be consistent in line with their salary and their policies within the company. Within someone's employment contract, they can stipulate what their sick pay. Some employers choose to say you are entitled to, for example, 8 weeks of contractual sick pay. We will pay you full pay or half pay for the first 8 weeks. And then for the 8 weeks after that, you have to go on the statutory sick pay. So that's a very common way of setting up sick pay. But it's not always the case that employers go about it in the right way. And it's very important to get it right. Paid leave. So again, holidays, it can get very sticky when calculating, especially if someone's on commission, or they get bonuses, or they work different hourly rates, they work part-time, because holiday calculation is quite a messy area. Saying that, there is a statutory minimum that we have in the UK, and then obviously, a bit like sick pay, employers can offer contractual entitlements on top of that. So what is usually the case, the employer will say, this is your statutory minimum, but contractually you get an extra 6 days on top. So sometimes people can end up with 30 days paid leave a year, and 25 of that is statutory. So that would be inclusive of bank holidays in this country. Obviously, not everyone offers bank holidays in the contract, as you will know. Lots of people work on bank holidays, petrol stations and so on, but that's the difference there. Notice periods, how to calculate them. Again, lots of maths required. Depending on the seniority of the employee, the notice period goes up. Depends how long you want to keep them. So, for example, if you're a very senior director and you hold lots of company secrets, your notice period could be 6 months. Quite rare and safe for those who are senior. If you're sort of mid-ranking, your notice period commonly is roughly 3 months. Obviously, there is a template for calculating it, which is 1 week for every year you're employed, up to a maximum of 12 weeks. So depending on how long they work for you, obviously there's a week each. But obviously, the longer they're with you, the more period that you can offer. Sometimes the employer offers a smaller notice period to the employee and requires the employee to give a greater notice period. There are differences, and it's quite careful how you go about it as well to make sure it's fair and consistent with the rest of the company. Deduction of income. Tim has already covered this a little bit. What is and isn't permitted? So we hear lots of horror stories about employers unlawfully deducting various amounts from people's wages without agreement, without consent, and without any legal basis, to be quite frank. Obviously, there are things you can deduct from the wages. Sometimes you'd have to put it in the employment contract, and the employee would have to agree to that deduction. But you've got to be careful you don't just deduct various amounts willy-nilly from your employee's income. Make sure you do that lawfully, and it is agreed if you do. What must be included in a contract of employment? We went through the main statutory rights at the beginning, but broadly speaking, the names of both parties, so the employee and the employer, the start date of your employment, your salary, your working hours, your working time, the amount of holiday you're due, what the sick pay is at the company, the complaints process, your responsibilities, your duties, essentially setting out the store of what you are to do and what you get in return for that. And there's various things you should and quite frankly must include in a contract of employment. As I said, how to calculate holiday pay, that is quite tricky. Variously easier done if you are a straightforward salaried employee, much more tricky if you're on an hourly rate, commission rate, part-time. That makes it more complicated. Probationary periods. When you first hire someone, you give them a probation period. Say your probation period, for example, is 6 months. Within that 6 months, unless you meet your targets or you perform to a certain standard, we won't keep you, and that's perfectly legitimate. But the employee's obviously got to be notified of this in their employment contract, and there'll be lots of terms and conditions within that. There are different rules for dismissal if someone's on probation as opposed to if they're employed. So that's something to watch out for. Restricted covenants. A big one in certain companies, especially to do with data protection and intellectual property and patents and copyright. A lot of employers are quite rightly worried that if an employee does leave them and goes and joins a competitor, they do not want their employee taking with them lots of secrets. So restricted covenants essentially are clauses in the employment contract that limit or restrict an employee from sharing with competitors or other employers what they know for a specific amount of time, known as a lockout period or potentially garden leave. Mobility clauses. So if you are employed in the UK, for example, but your job requires you to travel, then you have a mobility clause in there. Again, that's got to be carefully worded because you don't want it to seem as if you don't have a place to work and that you're some sort of nomad. That doesn't really bode well for the employee, especially when it comes to international immigration laws such as visas and work permits. That's got to be very carefully drafted. Garden leave, as I mentioned before, is a lockout period where the employee has given in his notice to move elsewhere, but they remain employed for a specified amount of time, for example, let's say 6 weeks, where they remain on payroll, but they are not allowed to work, and they're not allowed to start work for their new employer purely because the previous employer does not want them to take with any new information to the new employer. Quite common if you're senior and you know a lot of trade secrets. And then finally, calculating working and rest time. Tim's covered this. Again, fairly straightforward if you're a salaried employee with a set amount of hours and set amount of days a year. If you work on a part-time hourly basis, it's a little bit more tricky to work out what your maximum working time and maximum or minimum rest time is. These are all held within the working time regulations, which is a European directive, which has jurisdiction in the UK still to retain EU law. We've got to follow it and incorporate it into employment contracts. Again, that's a little bit of calculation. So a little bit of maths, a little bit of lawful common sense, but these would be the main things that you'd have a few issues with should there be a complex employment issue. So moving on to part 3. So we're going to be looking at hiring, managing and terminating employees, the 3 sort of stages of someone's job cycle. I'm going to cover off recruitment and hand back to Tim. A lot of people think recruiting is fairly easy, no pitfalls there. Not to worry, but there are things that can go wrong. So mainly speaking, as we referred to before, employers cannot discriminate during the recruitment process. And yes, that's even before this person's become an employee of yours. You can still put a foot wrong. You may already know that there are 9 characteristics that are protected within the Equality Act 2010. And these are age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. So employers are prohibited from direct discrimination against these characteristics, which is treating less favourably, so and indirect discrimination as well. Indirect discrimination is applying a practice or a provision to a person that puts them at a particular disadvantage when compared to others. So requiring someone with a physical impairment and treating them the same as someone who's physically fit, that would not be fair. That'd be putting them at a disadvantage. For example, requiring them to walk the stairs when clearly they need a lift, but that would come to something else. So where necessary, as I just said, employers must make reasonable adjustments for disabled people. So if you have an employee who's in a wheelchair, you are expected to, put in a ramp for them or install a lift should your office be on several floors. That's the duty employers have. And then obviously employers must take care when writing job adverts and exclude references to the characteristics as listed above, for example, age, gender, and race. So, what you shouldn't say is younger worker sought or mature worker preferred. Any references to a specific characteristic and that preference over others would be wrong, and you'd be at risk from complaints from potential job applicants. So whilst recruitment majority is within the employer's power to do as they like and find the right person for the job, they've got to be very mindful of the 9 characteristics that are protected and to take care not to discriminate, whether directly or indirectly, as I explained. So back to Tim to carry on with how to manage your employees.
Thanks, Alice. So day to day, we've got to a point now where we're aware of what our main obligations are as employers. We've successfully recruited, we've taken on an employee maybe at first, maybe we're growing a business as Stephen said at the start. So we're up and running now, and we're now on day-to-day managing of our employees. And some things that we need to be aware of. We've got our contract of employment. That's all compliant. It's got the information in that Alice just described. So day to day, what are we going to do to manage our employees? We've assumed that in terms of day to day, you've got payroll up and running. So you've got a system for booking and taking leave, and you're keeping count of that, etc. So we're now going to concentrate on 2 things. There are many. The 2 things we're going to concentrate on are, potentially when hiccups occur. Now, when you go into employing anyone, you hope everything will be fine, and I'm sure that's what most people want, and you hope it's going to be a good relationship, but that unfortunately isn't always the case. So you've always got to be aware that if things do go wrong, how are you going to be able to deal with it? And there's 2 things that you probably need as an employer, 2 basic tools you need. One is a disciplinary policy, and the other is a grievance policy. And you probably already think, well, I've had to draft this contract of employment and there's quite a lot of law involved. Now I've got to have these other things. They really are worthwhile having, and they don't need much time and effort actually to create, as we'll explain in a moment. So having a written policy both a disciplinary policy and a grievance policy with clear procedures helps you as an employer to stay compliant, and it helps you treat your employees consistently. And if anything does go wrong or you need them, you've then got a blueprint which you can go back to. It saves you time in the long run. Now, there's an organisation called ACAS that you may or may not have heard of. It's the Advisory, Conciliation and Arbitration Service. They're not part of government. They are not run by employers. They're not run by employees. They are truly independent, and they've got a very good reputation amongst both employees and employers. Now, ACAS provide a large number of free tools to employers that they can use. So if you're thinking about drafting these policies that we're now talking about, you don't have to start from scratch, because ACAS provide free-to-air templates, policies, advice and free materials to employees and employers. So if you need these things, look to ACAS first. ACAS also provide a code of practice on discipline and grievance matters. Now, the code of practice is not binding on you, don't have to follow it, but employment tribunals, if the worst happens and you ever have to go there, or you're ever taken there, employment tribunals will have regard to the extent to which you follow the ACAS code of practice. So we've got some free materials from ACAS there, a disciplinary and a grievance policy and a code, easy, fairly easy reading for you, fairly short, a good way for you to understand how do I manage a situation and what's a discipline and what's a grievance. A disciplinary policy, well, that is where the situation with the employee perhaps needs some attention, perhaps their performance has dropped, perhaps they're not coming into work, there's an issue with employment that you need to speak to them about. A grievance policy, that's where the employee comes to you and says, I'm not happy about something in work. I want you to look at this. I want you to deal with it, because they feel aggrieved at something that's happening in the course of their employment. So both situations happen regrettably reasonably commonly in the workplace. And these two policies will give you a roadmap for how you deal with both. If we move on to the next slide. Ending employment, I'll quickly deal with this slide and then hand back to Alice. So there are a number of ways in which the employment relationship can end. We've talked about hiring your first employee, the contract of employment. We've been managing the employment relationship, and now we'll look at the end of the relationship. 5 basic ways. 1, by some sort of legal default mechanism. Probably rare, but it does happen. So for the sake of completeness, the employer might become insolvent. The employee or the employer might pass away. Something like that just brings automatically the employment relationship to an end. By frustration, employment becomes impossible. Rare, but it can happen. And it can happen that the employee is just no longer able to perform their duties anymore, or the employer cannot any longer legally employ the employee. It's rare, but it happens. By agreement, that's more common, where the employer and the employee simply agree that they want to part ways. It may be very amicable, and that employment will cease. By resignation, that's the employee giving to the employer a notice saying, I no longer wish to work for you, I am going to leave. And we'll talk about resignation notice in a moment. By dismissal, and that's the employer telling the employee that they are terminating the employment contract, they're ending the employment relationship. There are various ways that dismissal operates. We will describe them in a moment for you. But there's a snapshot of how the employment relationship ends. If we move on to the next slide, and I'll hand back to Alice.
So as Tim just discussed, the sort of 5 main ways employee leaves the business, the employer. Ending employment by agreement is by far the most common, and that would be resignation, that they found another job, they want to move on for various reasons. And as we said before, both the employer and the employee must give notice. This can be contractual or statutory. As I said, the statutory was 1 week for every year of employment, or contractual could be a greater amount. So the employer has to give notice, as well as the employee, but the notice periods do not have to match. Employers can pay in lieu of notice. So if the employee really wants to get the skates on and move to their new job much more quickly than what their notice period allows. Let's say their notice period is 3 months and they want to start their new job within a month. The employer can just simply pay them their 3 months worth of salary and say goodbye immediately. And instead of working out their notice period, the employee can just move on to their new job much quickly. This is sometimes preferred by employers and employees where that situation arises. Sometimes employees want those 3 months to give themselves time to find a new job and would rather stay at the company for a bit longer, such as whether you've got quite a complex handover and you need to train up your replacement in your notice period. So either way, it has to be agreed between both parties. Dismissal. So you can't just sort of dismiss someone. There are different types of how you can dismiss an employee, and we'll go for the 4 basics here. So termination by the employer. So you've been sacked or you've been made redundant. Where a fixed term contract has run out and you don't renew it. So let's say you were a maternity leave cover, you've got a contract, a fixed contract for 12 months. When it runs out, that's it, you're done. Constructive dismissal. And this is fairly rare, but it does pop up every now and again. It's where an employer's conduct effectively forces the employee to resign. This means that there's been a falling out. The employer, in the employee's mind, has behaved in such a way they don't want to work for them anymore. And they've said that the employer's forced me to resign because it's that relationship has broken down. Summary dismissal, on the other hand, is where the employee terminates the employment immediately by giving notice or having their pile on there, which is what we just discussed. Those are the 4 most basic ways of how an employee is dismissed. The dismissal pitfalls. So we've mentioned this previously. Unfair dismissal pops up every now and again, and it's something you need to be very aware of. So as we said, all employees have a right not to be unfairly dismissed, but that only kicks in when they'd worked for you for 2 years. So they've got to have been employed by 2 years for this to apply. Reasons that are automatically unfair for dismissal will include things like protected characteristics. So we've got pregnancy there, birth, maternity, adoption. If there's been a takeover by a new owner, so the employer's sold their business out to someone else, you can't be dismissed purely just because someone new owns a business. That's unfair. And then if you are on a 0 hours contract, there's nothing stopping you working for another employer. Cannot be dismissed because you're on a 0 hours contract and you work for someone else. So those are some reasons that are automatically unfair. And then there's some grey areas. So there are some reasons that are potentially unfair to be dismissed for, subject to some more scrutiny. So whether you're capable enough for the job, capability, conduct, whether you know whose behaviour is good, redundancy. Redundancy, there are specific processes that you've got to follow as an employer before you just randomly pluck someone for redundancy. And then any other substantial reason, which is another way of saying other things that can be fair, but obviously can be unfair depending on which way the employer goes around it. So business reorganisation, a breakdown of trust between the parties, the refusal to accept contractual changes from the employee's side. So essentially minor fallings out that cause frustration between the employer and the employee. You can't automatically dismiss someone sometimes, given that some reasons, as you can see, are fairly complex. And finally, to safeguard both the employer and the employee, employers must always follow a fair procedure, e.g. the ACAS code of practice. It will future-proof any issues you have with what you must do when you in a situation like this. A procedure helps you to make sure you're doing it lawfully and in a fair way and in a consistent way with the rest of the company. Wrongful dismissal. This is a claim by an employee for breach of contract, something a little bit more serious and unfair. This is where the employee believes that the employer has breached the terms of the employment contract, and wishes to claim against them for essentially damages, which is money. The only entitlement that the employee can receive is any arrears of wages, so money they haven't been paid yet for work they've done. Obviously, their notice pay. So let's say 3 months notice, they're due 3 months pay. any benefits they would have received during their notice pay. For example, did they have a company car? Did they have expenses? Did they have a bonus? Did they have commission? Anything like that, they are due that. And then unpaid holidays. So do they have aggregated holiday that they haven't used yet a year? They would be due the unpaid holiday. So essentially money, but this is fairly common where obviously there's a falling out, but their claims are limited to the things I've just listed, and that's where there's a breach of contract by the employer. So final part, what else do I need to know? Whilst we've covered quite a lot in the hour we've done, there are a few more things we'd like to raise as things to be aware of. They're a little bit more detailed and in-depth for today because we were just focusing on the essentials, but when you become an employer, it's good to be aware of these things. So firstly, vicarious liability. What it really means is that employers usually are liable for the actions of their employees. So if an employee does something wrong or makes a mistake, usually it's the employer's responsibility to take liability for that action. The only time that employers aren't responsible for their employees' actions is when an employee is acting on a fault of their own. This means that if the employee is acting in the course of their employment, then the employer has to take liability. If the employee is doing something wrong, let's say outside of working hours, outside of work, and they're on a frolic of their own, then the employee is liable. Health and safety. Again, a really big thing, perhaps not so big in office buildings, but there are minimum things you have to comply with. So there are implied duties. There's quite a bit of statutory law there in the background. Health and Safety at Work Act 1974, really big piece of legislation there that applies to essentially all employers to ensure that your employees are safe and well at work. Big one, data protection. Every business needs to be registered with the ICO and have a privacy policy. Obviously things changed a bit after the UK left the EU, but GDPR and all of that, very important. Make sure the business has those policies in place. 4, compulsory employer insurance. Yes, that's right, you do need it as your employer. It's compulsory, no questions asked. 5, tricky area, tax, national insurance and pensions. Our advice is to instruct a company accountant. Don't do it yourself. It's very complicated. The POIE system is best suited to someone professionally trained. Calculating tax, national insurance and pensions is a minefield, and it's best delegated to someone qualified to do it. Obviously, it's these are the most expensive parts of the business, so important. Obviously, you need to have discussions about your annual accounts and your outgoings and ingoings with your accountant, but best left to someone who is more qualified. Finally, be cautious if you're going to take over another business. This is called 2P rights. This is sort of the protection for employees whose employer has been taken over by someone else. Generally speaking, they need to retain all the contractual rights from their previous employer. As I said, they can't just get kicked out. They can't have huge, massive changes to their employment contract. They sort of have to stay on what they originally were. This becomes quite tricky because you then might end up with 2 groups of employees, one group from the old company, one group from the new company, all on different terms and conditions, which may cause tensions with pay scales and a sense of unfairness. So that is quite a tricky area, but far too big to discuss today. And then finally, please contact Stephen for any follow-up questions after today. I hope this has been informative. I hope we've covered the essentials, things to be aware of, recruiting, managing and terminating employees. Lots to digest there, but hopefully you got the highlights. Thank you.
Excellent. Thank you, Alison. Tim. That was really useful, and yeah, a very thorough and informative run through of what our members need to know about employment law. And I've just got one question, if you don't mind, that came through from one of our members earlier in the week. And it's around managing, well, recruiting, I suppose, and managing international teams. So there's kind of 2 sides to it. So the first one is, how does this apply when you are recruiting people who are based in other parts of the world? And the second thing is actually a question for myself. When we look to employ people in Europe, for example, the CVs over there always have people's ages on them. They have people's photographs on them, which isn't how it works with UK employment law. So could you talk a bit about how those international differences interact with what you've talked about?
Of course, and actually, Stephen, it's a really common scenario because post-COVID, a lot of international employees in the UK went back home and they've stayed there. Or a lot of British people have decided that with this new popularity of working from home, that they want to work from home in Europe, for example. And so it's a really common question we get all the time, and it's not too difficult actually. So it's more about respecting the individual country's laws. So it's where you physically are, which helps. So if you're physically in the UK, you're within the jurisdiction of England and Wales. You have to comply with English employment law. You've got to have an English employment contract. You've got to be paying tax in England. Everything's to do with England. If I work in Portugal, but my employer is in the UK, I can still work for a UK employer. That's not an issue. It's just that everything I've just listed above has to be in Portugal. So I've got to be on a Portuguese payroll. I've got to have a Portuguese employment contract with Portuguese employment law terms and conditions. I've got to Portuguese everything about my employment rights. So nothing to do with the UK. The only thing that can happen is that on my Portuguese employment contract, ABC Limited UK is my employer, but they need to have a Portuguese payroll to ensure all my tax, national insurance, everything goes to the Portuguese authorities, Portuguese employment laws on my contract. So that's really important to be aware of. And it's right to ask, Stephen, because we've seen lots of cases where someone's gone back to Europe and they've stayed on English payroll, they've retained the English employment contract. Of course, none of that complies with where they are. So really good question, really important to be aware where your employees are, because that will dictate which rules apply. And then your second question was, remind me again, sorry, Stephen.
It was around the recruitment side. So, for example, you mentioned earlier about discrimination around age, for example, when you're recruiting someone in the UK. But in Europe, if you're looking to hire someone who's based in Brussels, the standard practice over there is that CVs have ages and they have photos of the applicants on them. So how do you protect yourself against claims of discrimination where the rules around CVs are different?
Yeah, absolutely. There are two approaches to take, and I think one of the terms is called unconscious bias. I think that's been a term used before, where employers receive training to train themselves out of subconsciously having a bias against certain applicants. The first thing we normally advise is it can be a cost, but shop around. Involving recruitment agencies helps you distance yourself from that first vetting of applicants. So what will happen if you use a recruitment agency? They will whittle down, maybe from 20 applicants to maybe the top 5, and they'll give you the top 5. And that's quite a nice indirect way to do it, because then you're giving that responsibility to a recruitment agency instead. Obviously, you have to give the recruitment agency what you want. Don't mention the age. Don't do anything like that. Just say, look, we want a competent worker who's skilled in this area, who's got some experience, whatever it is. So that's one approach to take. And the other approach is that on the job advert, you can request people to partially anonymize their CVs. So say when you apply for this job, obviously put your contact details on in your name, but we'd kindly request that you remove any information that refers to your age or your photo. And it's more about specifically designing that job advert to sort of future-proof you from any pitfalls that come along the way. So it's really crucial to get that job advert right. And that might mean, looking for some outside help in crafting that. So those would be my 2 top tips for that situation.
Great. No, that's really helpful. Thank you. Because it came as a surprise to me when we first tried to hire someone in Europe, and all of a sudden I was getting all these sort of glamorous headshots sent through, and I said, "Well, that's not the sort of series I've normally seen." Thank you. That was really helpful. And I just wanted to finish by saying that for our members who are watching this video, that they can contact you directly, or they can reach me. We'll share your contact details with this video, and you guys are happy to have a 30-minute conversation to go through any problems that they might have, and any questions that result from them watching this resource.
Perfect.
Perfect. So yeah, just left for me to say thank you, Alice. Thank you, Tim.
Thank you.
And please do, for the people watching this, send any questions through. Thanks.